Dear friends, you are always with me in spreading legal and forensic knowledge. Today, I thought appropriate to discuss a very important topic called public interest litigation (PIL). Probably this legal tool is very important because it provides the voice to the voiceless. It helps the helpless people. If we go to the origin in brief, in 1976, Justice Krishna Iyer and Justice P.N. Bhagwati, in a very celebrated case, Mumbai Kamgar Sabha versus State of Maharashtra. In this case, the very poor and marginalized Mazdoor, especially of cotton industry and the clothes and other things, they were actually being discriminated, they were being exploited by the owner of the mills. So, this union Kamgar Sabha introduced a case. The challenge before the Supreme Court was the locus standi, the doctrine of locus standi. Until and unless you have the locus to stand in the court, you cannot file a suit. What does it mean? What locus standi stand for? It means that the person whose interest has been hurted or there is any injury. Injury is not only physical injury, injury may be of reputation, injury may be in financial term, in social status and many more. So, the person who has some loss, may be monetary terms, any injury of different types, that can only approach the court to fight for his right. But in this case, it was a union. So, Honorable Supreme Court, considering the necessity to address the problems of the marginalized people, the voiceless people, they relax the doctrine of locus standi. And this was just seedling of PIL. This term was not used actually. Later in 1981, in S.P. Gupta versus Union of India, this was the very important case related to the appointment of the judges in superior courts, that means in High Court and Supreme Court of India. In addition to these important cases, another case which I want to flag is Hussain Ara versus State of Bihar in 1979. So, there are series of cases whereby PIL becomes a tool, and these two judges which I named you, Justice Krishna Iyer and Justice P.N. Bhagwati, they actually took lead to establish PIL in greater manner. Later on, several judgments came across. You might have heard the name of M.C. Mehta. He is an advocate and I think he is a crusader for protection of environment. Series of cases were introduced by him in Supreme Court as PIL. And one very important judgment I want to flag is oleum leakage case. It held in Delhi and lot of environmental degradation was made. In that particular judgment, Honorable Justice P.N. Bhagwati gave very important doctrine called absolute liability. There are two liability, one is called strict liability and another is called absolute liability. What is the difference between the two? In strict liability, whether you are negligent or not, if some damage has been done to somebody, then you have to pay back, you have to compensate. But in strict liability, there are certain exceptions. Precisely, there are 7 exceptions. For example, act of God or vis major. What does it mean? It means that some calamity or something by way of nature, if the damage is caused because of the natural calamity or something which is beyond control of the human being, then that is exception, you will not be liable for paying the compensation. Likewise, if it is the mistake of the plaintiff, the person who is asking or who is claiming for the damage, if fault lies with him or it is with his consent. So, there were some 7 such exceptions, but in case of absolute liability, which was actually brought in oleum leakage case, in absolute liability there is no exception at all. You have to pay for the damage caused to the plaintiff. So, various other domain, various other doctrines were called out by our judiciary. Likewise, in case of environmental protection, as I said, M.C. Mehta as a crusader, there were several very good doctrines introduced by our Honorable Supreme Court. One was the polluter pay. It was basically introduced after Stockholm Declaration of 1972. The Schedule 15 deals with polluter's pay. It means the person, the organization, any company who is responsible for spreading the pollution have to pay back, so that the technology, the other mitigating factors can be placed in and that impact of the loss will be nullified. So, there are so many other important area whereby the PIL has played very important role. Likewise, in Vellore Citizen Welfare Forum, I can cite various Taj trapezium case. In Dehradun Valley also the digging of the land, soil, various other PIL can be cited. But I want to take you to the another facet of PIL and especially the nexus between RTI and PIL. It is a very beautiful concept. Understand what I am going to say. Basically, when RTI means right to information. That Right to Information Act 2005 made a landscape change in our judicial process, particularly to enforce the public interest. Public interest, as I said, these type of PIL can be filed by public spirited identity. It may be a person or maybe any organization, maybe an NGO. So, what I mean to say that people start collecting information, particularly about projects, about some government schemes, policies, and based on those informations they went to file PIL. And this was a game changer to address the menace of corruption in India. You might remember various cases in line, like coal scam, then 2G scam, the Augusta Westland case where VVIP helicopters were purchased. I can cite n number of cases. The best part of RTI was that information was brought in black and white. It becomes the evidence in the courtroom, and based on that RTI information, people went to file PIL to address the high ticket cases, and lot of highly placed persons, organizations were booked. So, my dear friends, in totality, PIL is a very effective tool, but there always a flip side. In few cases, you may say that there is judicial overreach. Sometimes it is also blamed that certain people or certain organization, to get their name and fame, they brought in the frivolous PIL. Of course, any good thing, any good remedy, if not used properly, may have some flip side or may have some problems. But overall, in my opinion, and largely people believe it, that PIL has done wonders in not only in our country, but in other countries as well. It has given voice to the voiceless. It helped the helpless people, the women, the children, environment. You remember various other cases where women's rights have also been empowered, they have been strengthened. So, in totality, I can say that PIL is a very important weapon for helpless people. With this, thank you very much, giving me always very encouraging assessment, and let us move ahead to learn more and more to develop our nation to have a very livable world. Thank you very much. Bye. See you again. Thank you.